And of course, Justice Kavanaugh.
Well, in a war zone, though, in a combat zone, we have a line of cases, Garamendi, Crosby, you know all the cases, put aside Boyle. Boyle footnote 4 talks about this, but not Boyle, the rest of it, that says that there are certain areas where there's a uniquely federal interest. And in those areas, the usual preemption rules don't apply, that we expect Congress actually to speak clearly if they want to provide for something like state tort suits. And that's flipped. And it would think if you're talking about uniquely federal interests, there's nothing that's more uniquely federal than successfully fighting a war in a combat zone.
Certainly, Your Honor, we agree that Texas can't declare war on Mexico or New York can't invade Canada.
But can Texas regulate how the military structures its operations at Bagram, or can South Carolina regulate it? And you know, that raises another question here, which is pointed out by Judge Silberman in his opinion on this, which you're familiar with, which is, can 50 different jurisdictions regulate what's going on at Bagram?
Certainly, I'll address in turn. So as to the constitutional structural point, we know the default is common law claims are available. And it goes all the way back to cases like Little v. Barry, where Chief Justice Marshall, he upheld damages award against a Navy captain who was following the president's order. And also in cases like Mitchell versus Harmony, there was a common law claim against an Army colonel who seized an American citizen's property during the Mexican-American War in that case. So we do know this is certainly an area where Congress can certainly act, and Congress has done so.
Well, I agree with that, so I don't want this to sound like I disagree with that. Congress can certainly act. The question is, what's the baseline?
So the baseline.
And the baseline, I thought, under our case law going back, way back, if it's a uniquely federal interest, we have lots of cases saying something along those lines, that we require Congress to act to allow such suits. And we've said in, Crosby, for example, a failure to provide for preemption expressly may reflect nothing more than the settled character of implied preemption doctrine that courts will dependably apply. And so Congress, looking at this area, the idea that state tort law is going to regulate what goes on in Bagram, I think Congress will be like, sounds way out there, and not something that they need to get involved in because of the doctrine, as Crosby says, that is dependably applied.
Sure. So 2 responses, Your Honor. The first is the fact that military contractors might face some liability for acts occurring overseas U.S. bases was not lost on Congress. So Congress in 1941 passed a law called Defense Base Act. And what Congress did there was to exclude or preclude liability for government contractors occurring on U.S. bases as to their civilian employees that are under their supervision. So what that says is the fact that Congress, of course, operating against a background law like Little and Mitchell, knew that common law had a reach, even on foreign soil. And Congress certainly could have acted to take that back as to when it comes to American soldier who is injured by contractors.